Hello, I'm Attorney Dan Marr. I've been here at the Nashua law firm of Hamblett Kerrigan for 35 years, 36 years I've been practicing law. I did 1 year clerkship at the courts, and I've also been practicing law and licensed and practicing law in the Commonwealth of Massachusetts for about 28 years. So during that period of time, I've represented a lot of employers, and I want to talk today about what workplace speech looks like in New Hampshire for 2025. We have a new president coming aboard. We have the risk that Project 25 might take some traction that's going on. I'm not talking political, it's just most people will say Project 25 is way out there. But in any event, there's a question as to, for those who believe in certain more conservative religious beliefs or conservative political views, now that they will have a president that is agreeing with them in that situation, and also a conservative U.S. Supreme Court, do they now have constitutional freedom of speech in the private workplace? And the answer is no, you don't. The constitutional right of freedom of speech in the private workplace is the constitutional right of freedom of speech is the government's restriction of your speech. So if you were to go to a public park, and you want to espouse your political views or your religious views while you're largely going to be ignored by the people that are walking by you, you're allowed to do that, and the government can't take steps against you. In a private workplace, a little different for the public workplace, but in the private workplace, if your boss hears you in the causing a disruption in the workplace because you want to espouse why your religious beliefs are better than other people's religious beliefs, and if they don't believe if they don't convert, they're going to go to Hades. In that situation, at some level of that, while they have some freedom of religion rights, their disruption of the workplace is probably going to be a problem for them, and they should talk, and the employer should talk to the employment council, including myself, if I've dealt with this issue as to how far the employee can go in regards to that speech. Certainly if they're talking about their political views, they have no rights to talk about their political views. And while the employers generally, in my experience, good employers won't get involved with somebody espousing their views that are different than the employer's views, the owner's views, that's different than when they disrupt the workplace. You want a cohesive workplace, you want people to act professionally, you want them all rowing in the same direction to the benefit of the company. And if one person is a disruptor because he or she they just continuously want to talk about their opinions while they're supposed to be working, and they're disrupting their team so the team isn't cohesive, that's going to be a problem, and the employer can take action against them. In that, I've had a number of years ago, maybe 10, 15 years ago, I was sitting with a federal court judge who's still a really good judge in New Hampshire, and he explained in a table setting, social setting, we were having a discussion, and he was saying being a jerk's not a protected class. And he was talking about employment law, and it rings true still to this day. Being a jerk's not a protected class. If you're espousing your views and you're being a jerk, that's not appropriate. If you're in some type of protected class, but your actions are you're being a jerk, you don't get protection. The discrimination laws are dealing with actions being taken against you because of that protected class or protected activity, and being a jerk's not the protected class, nor is it the protected activity. So be careful about that as an employee, and as far as an employer. If somebody is disrupting the workplace and they're thinking, well, look, the president now has a consistent political view that I have, the Congress does, and the U.S. Supreme Court does, so therefore I can espouse this in the private workplace. They're incorrect, and we can talk about that if you have that situation, and maybe you can get them to have an epiphany and behave themselves, but if they don't, they can lose their job over it, because being a jerk is not a protected class. I've dealt with these issues for a number of years, and as it goes on in 2025, we're still going to have this law the way it is. There's not going to be constitutional freedom of speech in the workplace, in the private workplace. There is a right as speech as to work-related things. So not talking about your political views, not talking about how they should deal with the border in Mexico, or how we should be dealing with Canadian trade, or likewise talking about why somebody would, if they don't believe in your religious belief, is going to have a worse afterlife than you do. In that situation, if you're really talking about work-related things, about why the boss is not appropriate, why the company's wages aren't appropriate, those are protected. Those are called concerted activity if you're talking amongst your co-employees. Federal law protects you in regards to that. State law does too. So employers, you can't tell them to not do that, but you can have action, and you can talk to counsel about that, but you can do things to prevent the disruptive workplace as to political speech and other outside speech that are not work-related. I'm Dan Marr at the National Law Firm of Hamblett Kerrigan, and I'm at 603-883-5501. That's 603-883-5501. I've been doing this for 36 years. Happy to help with any employer that has a situation like this. You can check out our website too at NashuaLaw.com, NashuaLaw.com. Thank you. Look forward to the opportunity of working with you if the opportunity arises.